Thank you, Tom. Well, good morning, everyone, and welcome to this month's instalment of HR Matters. Unfortunately, we don't have any Tom Draper with us this morning, so Tom's got some pre-planned client business to attend to, so in his absence, I've been put on first slide duties today. For those of you who have not met before, my name's Lee Williams, and I'm an associate in the Freeths Employment Team in Sheffield, and I'm joined today by my colleague and managing associate of the Sheffield team, Toby Pochron. Before we kick off, unfortunately, I've got some bad news to share with you all. Well, it's some really bad news, actually, because it's been decided that, for the time being at least, today is going to be our last HR Matters webinar. You know, we're all really gutted too. And it's not been an easy decision for us to make this one, but given the lifting of restrictions, we thought that now was probably a good time to start thinking about our future events programme, and hopefully we'll be able to share some details with you about these in due course. We're also going to be focusing on our national programme of webinars, and Toby's going to give you a few more details about this at the end of today's webinar. But yeah, for now, this is going to be the last HR Matters webinar run by the Sheffield team. And for our last webinar, we've chosen the topic of settlement agreements. So for those of you who've been joining us regularly over recent months, you'll recall that we've dipped in and out of this topic, but we've never really gone into that much depth. So we thought today would be a good opportunity for us to do this, and it'll also serve as a fitting end to our HR Matters webinar series. So on that note, let's have a look at what we've got in store today then. So to kick us off, first of all, I'm going to look at what a settlement agreement is. I'm then going to talk about some of the key terms that we'd expect to find in settlement agreements and why it's important to get them right. I'll then look at why settlement agreements are used and explore some of the key benefits that settlement agreements can bring to your business. I'm then going to hand over to Toby, who's going to discuss protected conversations and the concept of without prejudice, the potential pitfalls when using settlement agreements, and to round things off, he's going to be providing some practical tips on negotiating settlement agreements for you to take away with you. And then, as usual, there'll be some time for us to answer your questions at the end. So as Tom says, if there is anything you'd like to ask, please pop these in the Q&A box at the bottom of your screen. So to kick us off then, let's start by looking at what a settlement agreement is. So a settlement agreement is a contract between an employer and an individual, and this individual is usually going to be an employee or a former employee. And under that, under the settlement agreement, the individual is going to agree not to bring a claim against their employer. And it's going to be in return for some kind of benefit. And the most common scenario where a settlement agreement is going to be used is at the end of an employee's employment. So it could be that the employee is to be made redundant, and the employee wants to avoid a process, or there's performance management issues, or disciplinary procedures being carried out, and there's benefit in getting rid of that process and agreeing a settlement without the cost and hassle of that process. In some cases, an employee's employment might have already terminated when a settlement agreement is offered. And usually this is going to be where an employee has already submitted a claim or is threatening to bring a claim. And in other cases, a settlement agreement might not relate to the termination of the employee's employment at all. So a dispute might have arisen during the course of employment, and it's intended that the employment will continue, but the parties want to agree a settlement to put the issue behind them. And in all these situations, the main reason for agreeing a settlement agreement is that it will bring a dispute to a close or prevent a dispute from happening. And it's going to act as a clean break between the employer and the employee, where both can put the past behind them and get on with their lives without troubling each other again. So what makes a settlement agreement different to other contracts is that it must be certified by a qualified independent advisor in order for it to be legally binding. And this is because under the settlement agreement, the employee is going to be waiving valuable legal rights. So the law says that because of this, they must receive advice from a qualified advisor first, so they properly understand what they're getting themselves into. And an advisor in this context is usually going to be a qualified solicitor in most cases, but there are other individuals, such as barristers, what can give this advice. And once a settlement agreement has been agreed and signed and it's been certified by the advisor, it will become binding like any other contract. So that means that if a party goes on to breach the terms of the agreement, they can be sued in the court for breach of contract, like under a normal contract. And as well as a settlement agreement, for those of you who are familiar with the tribunal litigation process, you might have also come across something called a COT3. And a COT3 is an agreement similar to a settlement agreement under which an employee agrees not to bring a claim against their employer. Or if they've already submitted a claim, then they'll agree to withdraw that claim. And unlike a settlement agreement, a COT3 can only be used after a referral has been made to ACAS. So for those of you familiar with the process, before an employee submits a claim to the Employment Tribunal, they must first go through ACAS, and ACAS will then attempt to conciliate between the parties to try and facilitate a settlement. If a settlement can be reached through ACAS, then I mean, this could be before a claim's being lodged, or it could be after a claim's being lodged, as ACAS will still facilitate that process. Then ACAS will assist the parties in putting together a COT3 form, which will record, like a settlement agreement, the terms of which has been agreed, the settlement terms. And there's benefits to the COT3 process. So one of these is that ACAS will act as a middleman, so they can send correspondence and assist with the process of getting the agreement agreed and signed. And also, unlike a settlement agreement, there's no need for an employee to get independent legal advice before entering into a COT3. So this can save the employer a few £100. But in some situations, it will be desirable to have even if a COT3 is an option, a settlement agreement will be more appropriate. And this is going to be where there's claims what cannot be settled by the COT3, where a settlement agreement is needed. And this is because, unlike a settlement agreement, a COT3 can only cover relevant proceedings, which are essentially claims which can be brought before the Employment Tribunal. So in most cases, this is going to be enough, but there are situations where other potential claims will be present. And the example I gave before was where, as part of the severance, an employee is going to be selling shares under a shareholders agreement. Any claims in relation to that are unlikely to be able to be settled under the COT3. So in this situation, a settlement agreement is going to be appropriate. Are we doing better now, Tom?
Yeah, that's perfectly, thank you.
Brilliant. So if we move on to slide 2 then. So now let's have a look at some of the terms that we would expect to see included in a settlement agreement. So the first on the list is notice. So as I mentioned earlier, it's common for a settlement agreement to be offered before an employee's employment terminates. And in this situation, one of the first clauses that we would draft into the settlement agreement would be in relation to the employee's notice period. And the notice period is important because the notice clause is important because it will state the date on which the employee's employment will come to an end. And there's many other terms in the agreement that will usually link to this date. So, for example, the agreement will usually state that the termination payment will become payable a certain number of days after the termination date. And another reason why this clause is important and why it's so important to get it right is because if you do get it wrong, then you could be in hot water with HMRC. And this is because there's strict tax rules that apply in relation to money paid under settlement agreements. And if an employee has not been given the proper notice that their employment will terminate, or will not be working their full notice period, the law states that the first part of any money paid under a settlement agreement must be taxed as something called post-employment notice pay. And there's a formula that can be used to work out what this period is, but essentially it's the period of notice that has not been properly served by the employee. And this applies even if the employee has resigned with a shorter notice period. So if they're not going to be working the full length of the contractual notice entitlement, it's likely that some tax is going to be due on notice pay under the settlement agreement. And as well as notice, all other payments and benefits relating to the employee's contract of employment that will be paid under the settlement agreement will also usually be taxable. So, for example, any accrued wages or holiday pay. Different tax rules apply to purely ex gratia payments that are made as compensation for the employee waiving the right to bring a claim. This payment will usually be defined in the agreement as a termination payment or a settlement agreement. And as long as the tax has been properly accounted for in relation to notice pay, then ex gratia compensation can usually be paid free of tax and NI up to 30 grand. And then anything over 30 grand will be subject to tax and employer's NI. And sometimes you'll see a settlement agreement what does not separate out all these different payments being made to the employee, and instead will just include one big lump sum. And that lump sum might include things like holiday pay, notice pay, compensation, and anything else. We'd not usually advise doing this, as it can make it more difficult to work out which parts of the lump sum is taxable and which parts aren't. And it makes it a lot clearer to understand when the agreement states how each payment has been calculated and what each element of it relates to. And this also makes it more clear to HMRC if they do decide to review the agreement terms. Staying on the topic of tax, another key term that we would expect a settlement agreement to contain is a tax indemnity clause. And because of the complicated tax rules, this clause is included as standard because if HMRC does pursue the employer for any unpaid tax on the termination payment, then the employer will be able to recover this money or can attempt to recover this money from the employee using this clause. In my short career, I've never come across any employer needing to rely on this clause, but it's usually put in the agreement as standard, as I said, and it offers just that extra layer of protection to employers. Next on the list, we have the waiver of claims clause. So this is probably the most important clause in the agreement from our perspective, because this is where the employee will be promising not to bring a claim against you. And under this clause, the agreement will set out all the different claims that the employee is being asked to waive. And this would include various statutory employment claims, as well as contract claims and personal injury claims. When drafting settlement agreements, we'll usually include a catch-all clause to cover any other claims that the employee may be able to bring. Legally, such a clause may not be enforceable, and case law suggests that each individual claim which is going to be waived should be identified clearly in the agreement. But this catch-all clause can act as a deterrent, and alongside it would usually include a warranty. And that warranty would state that all the claims listed in the agreement are the only claims that the employee has against their employer. So again, this offers another line of protection in the event that the employee does try and bring a claim that's not being identified in the agreement. There are some claims that an employer will not be able to contract out of under a settlement agreement. And the key ones you're probably used to seeing reference to are accrued pension rights and personal injury claims that haven't yet arisen and that the employee does not know about. Another example of a claim that can't be waived under a settlement agreement is a failure to inform and consult claim in relation to TUPE. And this will be relevant where a proposed TUPE transfer is about to take place. Sorry, I've just lost my notes. This will be relevant where a proposed TUPE transfer is about to take place, but for whatever reason, the employee will not be transferring to the new employer. And this is where settlement agreements can get extra complicated because it's usually going to be necessary to have three parties to the agreement, and that will be the employer, the employee, the employer, and the proposed transferee. And also the employee will need to sign a letter objecting to the transfer in order to prevent a failure to inform and consult claim arising, because they cannot waive that claim under the agreement. And get this wrong can be really costly, especially where you've got a number of employees that are going to be offered settlement agreements. So we'd always say take advice in these circumstances to make sure you do get it right. Moving on then, next on the slide we've got the reference. And as I'm going to cover in a bit more detail on the next slide, since a settlement agreement is a contract like any other, it's possible for the parties to agree pretty much anything. And one of the most common clauses that we will include in an agreement is an agreed reference. So a reference in a settlement agreement can be good for both parties because it prevents any disputes from arising in future when a new employer makes a reference request. And from an employee's perspective, one of their priorities when leaving the current employer is going to be securing alternative employment elsewhere. So an approved reference in these circumstances is going to be really important to them, especially where there's been misconduct or performance issues that have arisen in the past. And this doesn't mean that the reference should be deceiving, but for instance, it may be that a standard form reference can be agreed, just detailing the employee's dates of employment and the position that they held with their former employer. And from an employer's point of view, a reference can be a good bargaining tool in getting an employee or ex-employee to sign up to a settlement agreement. And it also means that the employee cannot come back to the employer in future in relation to a reference that's already been agreed. And it'll be just as important, it will be important to make sure that the agreed reference is actually the one what's provided. So just make sure that a note is made that if a reference request does come in, that it goes to the appropriate person so the agreed reference can be provided. So moving on then, next on the list we've got the confidentiality clause. And for those of you who've been involved in the negotiation of settlement agreements in the past, you'll probably have found that one of the most detailed provisions in there is the confidentiality clause. And there's many reasons why it's important to have a detailed confidentiality clause in a settlement agreement and to make sure that you get the drafting of it right. First of all, a good confidentiality clause should prevent the employee from discussing the settlement agreement with their colleagues. And this includes even the fact that a settlement agreement has been offered. So if other employees get wind of the fact that one of the colleagues being offered a chunk of money under a settlement agreement, then they could expect the same treatment, and this could possibly lead to accusations of unfairness. A confidentiality clause should also prevent the employee from making derogatory remarks about their employer and its employees, including on social media. Again, this is important because it it would be damaging if after you've just agreed to pay someone a decent sum of money, then they go and start slagging you off on Facebook and Twitter. So if this clause is included, then the individual is going to be a bit stupid to do this, because then it could lead to them having to pay any compensation back to you. And we'd usually draft the agreement so it has this effect. A well-drafted confidentiality clause should also clearly set out the employee's express and implied obligations of confidentiality under their employment contract. So the clause should include a clear definition of what amounts to confidential information and the restrictions what are on the employee when it comes to dealing with that confidential information. In making sure, however, that the confidentiality clause protects your business interests, there are some legal and ethical considerations that need to be taken into account. So for those of you who like to read the news, you might remember before the pandemic and everything became about COVID, that there were several articles being published in the press scrutinising employers who'd used settlement agreements for improper reasons. So for example, there were a few articles about employers who would use settlement agreements to gag women who had been subjected to sexual violence. And this led to a government consultation on the use of these clauses, and it's likely that we can expect to see some legislation in the future regulating their use. So in contemplation of this and to ensure that the agreement fits in with current law and best practice, we do need to put certain exceptions in the agreement to ensure that the employee is not improperly restricted from making certain disclosures that are in the public interest. So for example, provisions should not restrict employees from reporting criminal wrongdoing to the police or making protected disclosures into any of their employer's wrongdoing. Not on the slide, but closely related to this point is restrictive covenants. So these will be a key consideration for employers who are looking to exit an employee who's had access to lots of confidential information, such as details of key customers or other business contacts. And we'd always recommend getting advice on these matters, because the law is very strict when it comes to enforcing restrictive covenants. And you don't want to end up with a situation where you need to rely on a covenant, but then the employee's gone and got legal advice and their advisors told them that the covenant's not worth the paper that they're written on, which we do see with a lot of covenants what get put before us. So yeah, if restrictive covenants are going to be important, it will be important to take advice on this first. The last key clause that's identified on the slide is that of legal advice. So as mentioned earlier, in order for a settlement agreement to be binding, an employee's got to have received advice on its terms and effect from a qualified independent advisor. So the agreement will need to set out the details of the advisor and set out that the advice complies with the legislation regarding settlement agreements. And as mentioned earlier, this rule only applies to settlement agreements. It doesn't apply to ACAS Cot 3s. In these circumstances, it's usually expected, but it's not legally required, but it's expected that the employer will pay a contribution towards the legal advice that the employee is required to obtain before entering into the settlement agreement. And this is because the settlement agreement's for the employer's benefit as well. And usually it's going to have been the employer that has initiated the process. But this doesn't mean that you should feel compelled to pay any unreasonable legal costs that the employee chooses to incur. And instead, it's only expected for an employer to pay the employee for getting advice on the terms and effect of the agreement. So in most cases, depending on the employee's seniority and the length of the agreement, anything between about £250 and £500 plus VAT should be enough to cover the advice. If the employee then wants to take advice on other aspects, such as negotiating a better deal or other matters that have arisen, grievances, DSARs and all the rest of it, then it's usually going to be reasonable to expect the employee to pay for that advice themselves. Although, of course, your willingness to negotiate on legal fees is going to very much depend on the facts of each individual case. There's just one other clause that I'd like to cover, which is not on the slide, and that's the entire agreement clause. So you may have seen this clause popping up in settlement agreements and other agreements, such as employment contracts. And they're usually included in contracts as standard boilerplate clauses, but they're extremely important clauses when it comes to settlement agreements. And this is because the purpose and effect of an entire agreement clause in a settlement agreement is to extinguish any prior agreements and discussions so that the relationship going forward is subject to the terms of the settlement agreement only. But a potential issue when including this clause, it can be that in some cases you might actually want to retain some of the terms of a prior agreement. So for example, there might be some important intellectual property provisions or restrictive covenants in the employee's contract that you wish to keep. And if this is the case, it's going to be important to consider the effect of the entire agreement clause carefully. So if you do want to retain clauses from a prior agreement, these terms should either be transposed into the settlement agreement, or the entire agreement clause should be drafted so that the settlement agreement makes clear that the terms of the prior agreement are intended to survive the signing of the settlement agreement. So that's it for the terms of a settlement agreement that I'm going to cover today. I'm now just going to look briefly at some of the reasons why an employer might wish to enter into a settlement agreement in the first place. And this is when compared with other options that might be available to them. So looking at the slide, the first two bullet points are pretty self-explanatory. And this is if the alternative to a settlement agreement is a drawn-out formal performance management or redundancy procedure, or if a claim's already been brought, then a settlement agreement will enable you to avoid the time and costs associated with this process. And this is often the key reason for offering a settlement agreement, because although the employer might end up paying the employee money that they might not be able to recover in the employment tribunal, for example, if they were to lose their claim, the cost of instructing a firm of solicitors to defend the claim and the time commitment involved in instructing the solicitors, dealing with disclosure, potential DSARs, witness statements and all the rest of it will often vastly outweigh the cost of agreeing a settlement. And plus, in agreeing a settlement agreement, the employer's got the comfort of knowing that the matter has been resolved and then can focus on running its business without the fear of an ET1 dropping on its doorstep, for example. It's not only employers though, because even ignoring the financial aspect, there are benefits for employees as well. So they'll too be required to incur the significant time and expense in running a claim, and they are likely to favour the avoidance of a drawn out formal process if, for example, they are having performance issues at work. So yeah, it's usually going to be in both parties' interest to explore the idea of a settlement agreement if it is in appropriate circumstances. The next bullet point is about control. So we all hate uncertainty, and that's precisely what a tribunal process is. So we can never be 100% sure what a tribunal is going to decide on the day, and this applies to who will win the claim and the compensation that it's going to award if the employee does win. We can always give a reasoned assessment of what we think the outcome would be, but ultimately it's going to be up to the judge on the day to decide. So a settlement agreement avoids this uncertainty and puts the employer in charge of its own finances. As well as money, control also covers the terms of the settlement agreement contract. So as mentioned earlier, the parties have a vast amount of freedom when agreeing the terms of a settlement agreement. I've already covered some of them clauses, what you can include, so references, confidentiality, restrictive covenants. On top of these, you might also agree a departing announcement, arrangements in relation to shares, or even an offer of a new employment contract. And the tribunal doesn't have this freedom, so if an employee does go all the way and wins a claim, in most cases, the only remedy available is going to be compensation. So the settlement agreement gives you the opportunity for both parties to decide exactly how the clean break will happen. Next on the slide, we've got business reputation. So this is another common reason why employees will choose to use a settlement agreement. And we've already touched on the confidentiality aspect, which links closely with reputation. So by entering into a settlement agreement, the terms of the agreement should remain private between you and the employee, and subject to them exceptions that I mentioned earlier, the employee can be restricted from saying anything that would adversely affect the employee's interests going forward. In contrast, when a tribunal judgment has been given, it'll be published on the internet and be free for the employee to share and for anyone else to access, including the newspapers. So there's a clear benefit in getting a dispute resolved behind closed doors to prevent the possibility of a Daily Mail headline a few months later. And for those of you who do read the papers often, an employment tribunal judgment is an easy way for a journalist to fill in any leftover empty space. And I read quite a few papers and I'm seeing more and more of these cases being reported on a daily basis. So big interest in preventing this from happening, use a settlement agreement. The last two bullet points on the slide, confidentiality, which I think I've already covered in quite a bit of detail, and a clean break, which I think I've also covered. So I'm going to leave things there as far as my part is concerned. As mentioned before, if you've got any questions, and I can see a few of you have already done that, hopefully they're questions as well as just complaining about my sound quality. But if you do have any, pop them in the bottom and we'll get to them at the end. But for now, I'm going to pass you on to Toby, who's going to take us through the next part of the webinar. So on to you, Toby.
Amazing stuff. Thank you very much, Lee. Well, That's the first time I've spoken. Thank you very much for that great summary, Lee. It was great to hear all that through. What I'm going to be looking at in my part of the webinar today is a bit more about how businesses can make the actual offers of settlement agreements to employees without fear of these contents of those discussions being used against them later in an employment tribunal. It follows that if you want to pay someone 10 grand or offer them 10 grand to leave their employment, you want the security that they're not going to reject that, get to the end of a tribunal hearing and then say to a judge, look, they offered me 10 grand to go, therefore they must clearly be at fault. So there's two distinct ways that employers can get protection over the contents of the offers that they make to employees. They can do that either through protected conversations or by using the without prejudice principle. So I'm going to use the term protected conversations here. They are also known as pre-termination negotiations. I just prefer protected conversations myself. So protected conversations come from a piece of legislation, section 111A of the Employment Rights Act. And that says that any conversation that is protected or is made under that piece of law is protected from being admitted as evidence in ordinary unfair dismissal claims. So this covers off all pre-termination negotiations. It's the quote from the legislation, it's any offer made or discussion held before the termination of employment in question with a view to it being terminated on terms agreed between the employer and the employee. So it's not actually the phrase that you use that gives you the protection. So just calling something a protected conversation won't give you protection over it. It's the nature of the words that are used during that conversation that allows it to be protected from being admitted as evidence. So I use the term admissibility. Admissibility simply just means being allowed to be admitted as evidence in an employment tribunal. So the protection that surrounds protected conversations not only extends to the content of them, i.e. the offers that are made and the discussions that are held about someone's employment terminating, but they also extend to the very fact that discussions even took place. So they are completely blind in an ordinary unfair dismissal procedure. If you have a protected conversation that complies to the legislation, the very fact, the contents of it, the very fact that it took place is completely inadmissible. So a judge will never be able to consider it. And what they have to do is ensure they strike anything out like that out of their judgment or out of their contemplation as well. It essentially covers any pre-termination offer that you make to your employees, as long as they satisfy the necessary criteria. So with these, we get instructed sometimes where someone's come to us and said, oh, I made this offer to this employee and there's now a dispute about the contents of it. We then look quite critically at whether or not it was done within the remit of the legislation to decide whether protection exists or whether or not there's a potential that it doesn't exist, and therefore the content of that conversation would be admissible in a tribunal hearing. So it's always good to take legal advice just prior to having that conversation to make sure that we can ensure that it's tailored appropriately. So the separate rule on this is what's called without prejudice. So without prejudice is a common law rule. So it doesn't come from a statute, but enables parties to a dispute to communicate freely to facilitate the settlement of that dispute without fear that those communications will be disclosed later on. So where one party makes an offer that's without prejudice, the without prejudice principle extends not only to the content of that offer, but also to any response. So even if that response is a request for other information, an outright rejection, or a further attempt to settle, all those conversations would be privileged, so i.e. not admissible. Now, the without prejudice route is only available if there is a dispute in existence at the time when the offer was made, and it is a genuine attempt to settle that dispute. So it only applies when those two boxes are ticked. You've got to have a dispute and it has got to be a genuine attempt to settle that dispute. So that in and of itself is actually a slightly limited protection as it comes to protected conversations. Not only is the fact that, or the very fact that a without prejudice conversation even took place, that is still admissible. So you can say we had without prejudice discussions, that would be admissible in an employment tribunal. That's different obviously to protected conversations where that's simply not covered. Now you can have an offer that's covered by both pre-termination negotiations, so both protected conversations and also without prejudice as well. But without prejudice can only be applicable where there is an existing dispute already in place, or where there is a reasonable consideration that there's going to be legal action taken. So if an employee is raising grievances that say things like, I'm going to see you in an employment tribunal, might bring that complaint, there's probably going to be a dispute there, but the without prejudice principle only kicks in at that point. Normally, as I say, you see without prejudice dealt with after an employment has terminated. So pre-termination negotiations by their very nature can only take place before employment terminates. Without prejudice negotiations can take place at any time, as long as there is a dispute in place already. But there are nuances to this as well, because the offer that you make has to be a genuine attempt to settle the dispute. So there's a piece of case law on this called Hudson and Oxford University. What happened was that the claimant in that scenario had been dismissed, and he appealed his dismissal. And the university wrote to him and said, well, look, your appeal is being held at the moment, but look, there is no reasonable prospect of you returning to work. So we're gonna engage with you in a way to avoid you having to come back with us. And the dispute at that time was about whether or not that claimant's appeal should have been successful or not. So by the employer, so by the university coming back and saying to him, there's no reasonable prospects of you ever returning to work, actually that isn't, and it was deemed by the Court of Appeal to not be a genuine attempt to settle the dispute that was in existence. So the dispute itself was whether you could go back, and they're saying you can never come back. So that meant that the substance of that offer, would have been a perfectly normal offer for a university to make, but the substance of that particular offer was not then covered by the without prejudice principle. That also then meant that the contents of that letter saying there's no reasonable prospect of you returning would have been put in front of an employment tribunal judge. And that's obviously really damning if you're also saying openly, well, so not covered by privilege, we're going to deal with your appeal fairly and we'll consider whether or not you're going to be reinstated. So, without prejudice can seem very, very broad brush, and it can seem this like really attractive thing for employers to use, but actually it is incredibly nuanced. And if you don't get it quite right, or you don't try to settle the actual dispute that's in place, it simply gets voided, and then you've got yourself in some hot soup. Now, the purpose of protected conversations was to kind of avoid this. It was to avoid the fact that there was a need for a dispute to be in place. The government decided that actually resolving employment law disputes might come out with a general sense of sort of grievance, maybe, or a general sense of kind of maybe a bit of upset, where it hasn't really ticked over into being a formal legal dispute. So they decided actually what protected conversations can do is bridge that gap. As long as it's during the period of employment, we can have this principle that allows for an employer and employee to have this kind of out of the blue conversation. So an employee might be walking along absolutely fine, no implications that they might be leaving their employment. Employer sort of pulls them in and says, we're not really happy with how you're working. Here's this proposal for you to go. Or we're contemplating a redundancy process. Here's a proposal for you to go because we want to avoid going through that with you. Neither of those two examples would be covered by without prejudice because there'd be no dispute, but they would potentially be covered by a protected conversation. But, and a big but here, protected conversations, they are somewhat limited in their protection, as the admissibility of the evidence only applies to ordinary unfair dismissal claims. So where someone says, I was unfairly dismissed, that gross misconduct wasn't actually gross misconduct, it was something else, you only wanted me out because you don't really like me, right? So what they don't cover is anything other than that. So they don't cover discrimination claims, they don't cover whistleblowing claims, they don't cover claims for protecting a statutory right or breach of contract. And it's designed so that the protection isn't just completely all-encompassing so as to allow an employer to misuse it. To allow them to cover off a discrimination claim that might arise. So what they are designed to do is really just to settle those initial pre-termination issues that an employer might have, little sort of niggles, things that just aren't quite right with an employee. They're not really something that might tick over into being, a proper full dispute. They're not quite something that you can really challenge through a capability process without taking quite a long time to do it. It allows you just that little bit of comfort to have that principle put in place and to allow you to have those negotiations. Again, with both of these principles, it's the content of them that garners the protection, not just simply the term that you use for them. I've had loads of emails from normally from litigants in person who cover things without prejudice. They'll just stamp the words without prejudice on an email, and actually the contents of that email it should be completely open. It's not something that's tried to settle the disputes in there. And I think people use it as a way of trying to make things sound a bit more formal or a bit more lawyery. The protection for both of them doesn't cover anything like fraud or undue influence or what that prejudice principle we call unambiguous impropriety. That's something that you're trying to perjure yourself or blackmail someone into doing something. So the without prejudice cover isn't just so you can make whatever disclosures you like or threaten people into trying to get them to settle with you, but actually it allows you only to genuinely settle that dispute. Now, that principle, this unambiguous impropriety, is moved over into protected conversations as well. So the statute, you can't do anything that would be deemed to be improper behaviour during a protected conversation and still expect for the protection to exist. So improper behaviour, this comes from the ACAS Code of Practice, is things like harassment, bullying, physical threats of violence, any type of victimization, discrimination, or the most common one that I see is putting undue pressure. That's one where it's most commonly argued. And the examples of that are not giving people enough time to consider the contents of the settlement agreement or the offer. So saying like, you need to decide right now, that would be improper. You need to give people a decent period of time, a reasonable period to consider it. By saying things like, if you don't accept this, we are going to sack you. Not just we might start potentially a disciplinary process with you, we might engage you in a redundancy process, simply saying to them, actually, no, we will dismiss, you will be dismissed if you don't accept this. That would be improper, be undue pressure. Or on the counter side of this, an employee threatening to undermine an organization in public. So saying, I know about all this, if you don't settle with me, I'm going to tell everyone about this. I'm going to damage your reputation if you don't sign this agreement. So it does kind of go both ways. Normally they're designed to be a bit more amicable than this. You tend to see this this type of requirement, but the most commonly missed one, I think, is the not giving reasonable time for consideration. So the issue with making any type of offer to an employee is that if they reject it, they're still in your employment. Certainly with pre-termination negotiations, they're still there. But what they do now know is that you want to get rid of them. And that can cause more issues than it resolves. And again, what they're going to be coming up with is, well, actually, what you want out of this is me gone. And I now know that. And whilst the protection might exist over the terms of the conversation, so let's say like a redundancy, for instance, right? In a redundancy process, you say, we've got 10 people and one of them needs to go. We think it's going to be you. Here's an offer for you to go. Now, we haven't made any decisions, but here's an offer for you to go. That employee says, no, I want my job. I'm not accepting that proposal. And then you go into the redundancy consultation and that individual now knows, or reasonably suspect, that they're going to get terminated. They will much more likely to cause an issue during that redundancy process than they would have done before. And they'll think, even if it isn't unfair, that it was unfair because they were being targeted. They were the person who was selected to go prior to the consultation, even starting off. So it's not just this kind of potential for a great agreement really, really quickly, as it can cause these aspects to backfire. And so that very wonderfully, as almost if you planned it, leads me on to my next slide, which is just looking at potential pitfalls. So if you can move me on, please. Amazing, thank you. So there are a couple of kind of core pitfalls that we see with settlement agreements. The first one, being too quick to offer them. I know we've been in business. I've been in businesses quite a few times who they just get into that culture. They get into the habit of offering settlement agreements out to people. And the problem being is that that can get A, quite costly. B, it's somewhat of a sticking plaster to try to cover off maybe a poor culture that goes along. Businesses who have got a lot of settlement agreements very quickly probably just need to be looking at employee relations and the underlying issues to those and why people are trying to leave before they try to settle people out, before they try to get people out of their business. But equally, you can put all the confidentiality provisions in that you like. Employees might talk to each other. They might talk to each other. They say, I did this and I got this payment out of it. It's just very, very difficult to prove where that other type of information has come from. And we get instructed by employers all the time to kind of say, well, we think that these people are talking to each other. We think that these people are colluding together, trying to extort us for settlement agreements. And it's just it's proving it, getting the evidence out. So not being too quick to offer a settlement agreement. Always consider whether or not you have an alternative. So that moves on to this. Having no backup plan. What are the alternatives to settlement agreements? The alternatives to settlement agreements are fair dismissals. There's fair processes you can use, fair disciplinaries, fair redundancies, fair capability procedures. You generally use settlement agreements, as Lee said before, in order to avoid having to go through those processes where either that actually it's not going to turn out very well, or it's just going to be an absolutely ginormous headache in going through it. Or to be frank, you're getting down with someone who's been with you for 20 years, they're no longer up to scratch, but you don't want to go through a capability process with them because it doesn't reflect how their employment has been for that period of time. So that's what I would call the goodness of your heart settlement agreements. They're designed to avoid those processes, but also to give that employee a benefit for their years and years of hard work with you. It's always good to have a backup plan. You don't want to be just painted into this corner where you have to make that offer, where you have to only go through a settlement agreement. Not least because that's not good kind of HR practice, but also because it leads you to paying out more. If you know you've not got anywhere else to go, you're going to have to settle with them, not maybe for exactly what they want, but higher sum than what you would want to achieve. So we do a balancing exercise with it. It's what would this potential liability be in the employment tribunal? What's my management time and cost in getting to this point? How long is it going to take me to go through a reasonable process? What's the potential risk? Add all those together, and we work out a tolerance figure for how much we can offer that person. If that offer goes above that, we don't accept it because we know this is where we're going to move on from it, and we know it's going to cost us less to get there, and we'll have to take on that time. It's an overall assessment of time and cost that gets us to those settlement figures, but it's always worth having that backup plan of, well, if they don't accept it, what are we going to do? Normally, it's some sort of other fair process. They can also create other claims as well. You make an offer. In that offer, you accidentally say something that might potentially be discriminatory. So say a common example I'd seen would be a woman who's about to go on maternity leave. She's then offered a settlement agreement just prior to her going. Links that to her pregnancy, might well be connected, not quite sure. If it's linked to that pregnancy, then it's potentially discriminatory conduct or it's improper behaviour. Trying to get me out, you don't want me back, and that's because of my pregnancy and my maternity. That's a discrimination claim, not covered by protected conversations, not covered by pre-termination negotiation, and there might have been a dispute in place and not covered by without prejudice. So they can create those other claims. It's worthwhile just checking to make sure that the situation covers you off you using that type of agreement rather than another process. Mistakes and omissions from the terms. This is always an interesting one as well. The common one is missing out restrictive covenants. You stick an entire agreement clause in a settlement agreement, and that person had restrictive covenants in their contract of employment. The entire agreement clause wipes those restrictive covenants out. So not only have you just paid that person off to leave, they're also able to trade freely and to contact your customers and clients. It's those types of ones where it's so valuable in taking legal advice, because either we can go through the restrictive covenants and make sure that they're correct, and then redraft them and put them into a settlement agreement if there's any deficiencies in there, or to make sure that any good restrictive covenants aren't waived. Confidentiality. As Lee said, it really did hit the press. It was the Harvey Weinstein affair, and some of the confidentiality agreements that were put in place were just so incredibly onerous. They were just designed to be punitive, to stop people from talking about a potential allegation that happened. It was often sexual harassment. There's new guidance on these. This has been a real big change for employment lawyers, certainly. So we have gone through quite a period of consultation in terms of amending confidentiality provisions so that they balance the need of the business to draw a line under it and to have reasonable protections in terms of confidentiality, but also the public policy argument that still allows people to seek medical help or report crimes that have taken place as well. There was always that principle. There is always a principle of protected disclosures never being allowed to be suppressed by the terms of a settlement agreement. But what you don't want to have is this fear that that person would breach it by doing something that would be in the public interest. So again, having that balance to it, because if you put in a confidentiality provision that is too onerous, it will be voided and it will be unenforceable. And then what you've tried to do is to get yourself to a time where you're best protected. And by doing that as an employer, you've actually completely voided your protection. So I'll take you on to some practical tips as sort of my last slide. You've got to consider, first and foremost, is a settlement agreement the best option? at the start of it. You know, as I said before, for long capability processes, you know, then it is a good process to use. Where you've got a good relationship with somebody, then that's a good one to use. If you want to target people during a redundancy process, they can be really, really useful. But we're always considering what the kind of the plausible alternative to those ones are. So what would have been the position but for the fact that I'm making this offer. Now, this next one here, just, you know, making an effective offer, it is really nuanced, and I'd say, and time again, I think it's a bit of an art to kind of making a proposal that's going to then be accepted, because these, you know, the times when you make these proposals to employees, none of them are going to be exactly the same. You know, they're going to be different situations for different people, but also you'll know how that person's likely to kind of consider it. So making an effective offer depends on the situation that that employee finds himself in. So say that employee is on long-term sick, right? Long-term sick, doesn't look like they're going to return. They've made sounds that they don't really want to return. We don't want to have to go through a long and lengthy you know, medical review process with them. We can make them a proposal through a settlement agreement. Now that offer is going to be darn sight different to someone who has potentially committed an act of gross misconduct, that is making loads of noises about wanting to sue us, making loads of public access requests, or trying to get loads of documentation from us, and we're just settling out with them to avoid the fallout that comes from it. So the offer that we make to the person on long-term sick, we'll probably give them a significant amount of time to consider it. It might well be more generous than the one we give to somebody else. And the other person who's making up the threats to us, A, it might be a leaner offer, but B, the offer might require them to settle within a shorter period of time as well. You know, the abruptness about how you deal with that as well is quite key. It can be that you get, I mean, I had an offer from a claimant that was, gosh, it must have been about 14 sides long, with this just no full stops, just a complete diatribe of information, and making just massive, very harsh allegations against my client and a lot of the senior managers that's in there. And the style that we used to go back to them was to just simply not engage with it. You know, just say, you know, we got that, but here's what we're willing to propose to you. And then, you know, the response to that was this another huge sort of email chain. And what you're trying to then do at that point is to not engage with them at that very early stage. A, to not give them any particular ammunition to come back to you on it, but B, just to show them as well that our focus at that point in time is just on negotiation. And again, you're going through an employment tribunal claim, and you can end up kind of getting into this mix of kind of pontificating. So you have your claims set out by a claimant, and when we're responding to it with our offers that are going through that, my preference always is to say to them, we're not going to discuss with you the merits of your claim, because you know we think your claim's tosh. Probably don't say that, but I say, you know, where's a bit more appropriate, a bit more professional to that effect. But you know what our thoughts are in terms of your claim. We're not going to go into that with you. We're just going to talk cold cash. You know, we're just going to talk about how we can get this resolved. And I think that it's that style of it, but having the forethought to think, well, what's going to achieve the best offer? That's the best way, I think, to do it. Making an effective offer will always highlight the benefits to it. You know, highlight the benefits, state the alternatives, what might happen if this can't be agreed, you know, what are the potential outlines, set a deadline, and then reduce the need for any questions that arise from it. If you're making an offer to an employee during the period of their employment, they're going to want to know a lot of information. If you give them 10 days that is required by ACAS guidelines to consider the content of that offer, and then they come back to you with a question on the 9th day, that has the potential to leave it over the top of that 10 days and it's still not resolved. So there's ways around that. Is you either make them the offer with sufficient detail so they don't have to make those questions and leave to the very last minute, or you set their final day as the 10th day, and you say to them, you know, regardless of when you accept this, that final day will always be the same. And I've been doing settlement agreements for about 10 years, and you know, it's about making those sort of little changes to how you're doing it that's going to then achieve the benefit that you want to get from it. And I mean, the last one we've always got there is just take legal advice. You know, I've been doing this for such a long time, and you see them in so many different wonderful ways. I mean, I've had employees who've struck out the requirement for legal advice on the back of a page, say, I don't want to take legal advice, I waive my rights. And on its face, an employer might think, oh, hey, great, they've waived their right, we don't have to pay for their solicitor's fees now. But that voids the agreement. You would pay that employee in that scenario, they would get the cash and have waived none of their claims. So it's completely, it's awful to think about at the end of it, but it might be something that you're thinking, well, that seems like it might be okay. Or again, you know, there's substance within those contracts that just need to be in there. They just need to be expressed out. They're all completely lawful, and you know, they will do the best to protect the employer at those times. It's always best to take legal advice. My very final comment, I've got my notes here, is to say, don't settle for anything else than using Freeths. And I wrote underneath it, do a cheesy wink, but I think I'll probably leave that out. So thank you all very much for listening. We do have some questions that come through. So Tom, does our next slide have our faces and our details on it? Could you click us over to that one, please? Cheers. So we've had some questions that have come in sort of prior, and we've got some in the Q&A box as well. So I do know we are running close to 11. So what I'll do is we'll kick those off. But just before I do that, as Lee said at the start, this is the very final HR Matters webinar. So we thank you all so much for your support kind of over the years that we've been running these. We've really enjoyed doing them. I mean, if nothing else, I love being the center of attention. So having everyone log on just to listen to what I have to say is a great delight for me. I think they're a great way of engaging with our audience and a great way of engaging with our clients. It was interesting because HR Matters started off as a collective group for HR people that we deal with. They were generally face-to-face, and it was designed so that we could all collaboratively share ideas and experiences. So we do them in the office here. So yeah, I'm in the office, it's not my house. Do them in the office here, and we would all share, you know, we'd have a practice scenario that we'd work through, and we'd share that approach to it. And it's sort of expanded out from that into being this big list of people who attend them so regularly, and we get such great comments and questions on it. So I can see the comments sort of coming in through the chat. You know, thank you all so much for attending them. However, this is not the end of these webinars. So we are changing them from being HR Matters to focusing on our national events. So what we're going to be doing is feeding in our webinar program into a wider use of all of our national lawyers as well. So about 40 employment lawyers up and down the country. We're going to be doing much more of these types of events still. It's going to be new branding. It's going to be new content. You're going to see new people doing it, but we will still pop up. So to move on from that very sort of gushy final way, I've got a couple of questions that we had beforehand, and then we'll run through these Q&As. So Lee, I've got the first one for you, if that's all right. So I've got compromise agreements changed to settlement agreements several years ago. What has changed in terms of the settlement agreement content?
Not much really. So as you say, a few years ago, in 2013, settlement agreements were called compromise agreements, and the law came in to change the name to settlement agreements because the government thought that the word compromise made it less likely that people would enter into one because they didn't want to be seen to compromise. So it's pretty much just a name change. I mean, naturally over time the terms of agreements change and you get more detail in there and all the rest of it, but as a result in 2013 it was just a name change. Probably more importantly was around the same time was when the concept of a protected conversation came about. So that's probably had more effect on the direction of settlement agreements than the name change. I'm not going to go into protected conversations again because Toby's just given a wonderful update on them. But yeah, pretty much a name change in the hope that more people would be willing to settle than compromise.
Yeah, spot on. I mean, I remember it. I remember when they did change. I just had to change all of my letters. I had to change them all the words from being compromise to being settlement instead. So I've got one here. Can you utilise settlement agreements if there is a potential discrimination complaint being raised? And would you consider issuing a settlement agreement for someone with less than 2 years service, and then in what circumstances? So I guess those two questions are kind of linked together. So yeah, you can use settlement agreements to settle discrimination complaints. You know, normally those are on the back of doing something else beyond it. So if you think that there's been sex discrimination, for instance, normally you would agree that there would be some level of other action that's taken. So unless it's just completely denying that ever took place, normally you say to someone, well, we're going to settle out your claim, but also these are the structures will be put in place, be training or other type of equality and diversity work that's put around that, and that goes some way as to alleviating some level of that dispute. And then for people less than 2 years service, I mean, for less than 2 years service, you can still bring discrimination complaints. You can still bring statutory complaints as well. So if you complain about your pay, you can be dismissed for that. If you complain about not having flexible working rights, you get a detriment for that. That's less than 2 years service. There's quite a lot of claims that you can still bring if you've got less than 2 years. It's really ordinary unfair dismissal that ticks it over that 2 year barrier. So if there's a valid claim there that might be brought, then it's a good one to go through. Or to be honest with you, I see them a lot where someone's just been hired, they're not quite right for the role, and the employer thinks it's not really their fault, it's not really our fault. But we want to be decent to them, and we'll make some sort of payment to them to run that through. So that's when I've seen them as being less than 2 years. Lee, I've got one here that you kind of covered off a bit before. So it says an employee has an occupational injury, so a personal injury, the insurer will pay. Should they lead the settlement discussions, including ending employment and the employer contributing to cost, or should the employer end employment and get the insurer to contribute to settlement? The concern is that the employee could get payment from the insurer and payment from the employer. They said the word double bubble, and the insurer won't also end employment. What do you think about that one?
So I'll let you contribute to this one if I've missed anything. But my thoughts on this are, first of all, I'd speak to the insurer, because the last thing you want to do is end the employment under a settlement agreement and compromise that personal injury claim. I mean, as I mentioned, you can settle a personal injury claim under a settlement agreement, but if the insurers agree to pay that, then obviously you're going to need to bear that in mind in the drafting of the settlement agreement. There's nothing saying that you won't be able to lead those settlement discussions in relation to the termination, but I'd sort of liaise with the insurance company first and see how they want to do things.
I mean, the settlement agreements themselves, if it was trying to waive a personal injury claim, they say that anyway. They say that you can waive personal injury claims that you're aware of. But B, if you were doing that, you'd include that expressly and say that these claims were going to be waived. But I wanted recently for a permanent health insurance, and that was there was an insurer who was contributing to it. So we had just a tripartite agreement that payment comes in. So you can do that, but it'd be very unlikely that they ever get double payment. Next one, is the employer obliged to pay the fees of an employee's qualified independent advisor? Our unions often outsource this to their legal advisors and expect us to pick up the tab even though the union is representing the employee. The very short answer to that is no, you are not obliged to pay legal fees for the employee. It's just grown up as a way of working. Generally, it's designed because you make an offer to the employee, they have to take legal advice for the offer to be binding. It's in the employer's benefit for them to settle their claims for some reason, but there is no formal requirement for you to take that step. It just greases the wheels, because if you've made them an offer of £5,000 and that's just about their entitlement, and then they've got to pay 250 quid, 350 quid to get advice, it just has the ability to stop them from taking that step. So we suggest it's a good idea. It just smooths it over. It's part of the process, but no, you're not obliged to do it. Okay. Says in the Lee, do you want to have a crack at this one? In the circumstances of a TUPE transfer, would it be more beneficial to use a COT3 through ACAS? So
as I mentioned, you can't settle an informal consult claim through a settlement agreement. That is one of the claims what ACAS can conciliate in relation to, so you can waive that claim under a COT3. The difficulty is, if you've got to the point of a COT3, then it's possible that the employee's already brought a claim and that the TUPE has already happened. So it might be that if you are, as part of the TUPE planning, you're offering settlement agreements to avoid that claim in the first place, then a settlement agreement might be more appropriate in that circumstance. Or if, like I said before, there's certain things you can't include in a COT3. So if you want in a comprehensive agreement, which includes other claims as well, then you're looking at the settlement agreement option, but with the extra part where you'd get the employee to object to the transfer so that claim doesn't arise in the first place.
Yeah, I mean, I know also good luck in getting ACAS to try and help you with that one. ACAS generally only help where there's an actual dispute or there might be a claim brought in the tribunal. They won't help if you just already agreed something with that employee. So we've got a couple more here. When we've done settlement agreements and an agreed reference, we've sent this to a prospective employer. However, we sometimes receive a follow-up question to ask us if it is an agreed reference under an agreement, or we receive a tick box reference request. What would you advise good practice in terms of responses? I would advise you look back at the settlement agreement itself. If the settlement agreement says we will only provide an agreed reference and nothing more, which is what it should say, then that's it. If they ask for, is it an agreed reference under an agreement, that potentially breaches confidentiality, and I would refuse to provide any further information. But the whole point of the settlement agreement is that it's clear exactly on what reference will be provided. So the reference will be provided is the contents of that reference that's on the back, probably in the form that it's provided to. So tick box reference requests, again, that's not it. What we will do is we will send out the exact form that we've agreed. The difference to that would be where we said something along the lines of, and we will ensure that any references does not deviate from these terms. So as long as we were able to respond to that reference request in the same terms as we'd agreed, then we're fine to go. If that employee later on down the line finds that actually the substance of that reference doesn't really help them out, that's not really our concern. We've done our job in terms of agreeing the exact form of reference that we will provide. So we've got another one here. We have a potential settlement where the employee has asked that we waive their training costs rather than recovering at resignation. Will we still need to offer a lump sum, or can the settlement agreement comfortably offer just to waive the training costs?
Lee, that one.
Yeah, have you come across that one before?
Yeah, so yeah, we've come across this one before, and it's up to you. I mean, it's likely going to involve a calculation of how much they owe you and how much you're willing to settle with them. But yeah, the settlement agreement can do it either way. So work out how much, whether you want to pay them anything or nothing, if it's extinguished completely by the training costs, and just set that out in the agreement. And that's one of the amazing things about settlement agreements. You can pretty much agree anything you want. We did miss a question, Toby, just before, another one on references. Yeah. And it was, do you want me to read the question out and answer it? Yeah. So we'd welcome your thoughts whether a reference request has been received for an ex-employee with a settlement agreement in place. The reference request asks about a safeguarding concern. While there is a duty to adhere to the reference agreed, it does raise an ethical and possibly duty-bound obligation. Any thoughts on how best to manage would be welcome. So if you do look in the settlement agreement, and we covered this briefly earlier, there's going to be exceptions in there, potentially in the reference clause itself, where it says the employer can diverge from that reference if there is a safeguarding concern to raise, for example. But also if you look in the confidentiality clause as well, there's likely going to be some, or there should be some terms in there what doesn't restrict you from making that disclosure if you have to because of a regulator or by law. So usually, yeah, you would be fine, but I would check the terms of the agreement first. And if there is a legal duty to make a disclosure, then you should be making it.
Yeah, spot on. I mean, that's also a point for drafting too. So if you, once you're agreeing that request, you'd be saying within that, but please be aware that if we're required by law to deviate from this request, then we will be doing so. Again, that's where, say if you're settling a claim through a COT3, ACAS do provide COT3s. You know, they can assist unrepresented parties in producing it, but things like this, you know, that would potentially be excluded by the terms of a normal ACAS COT3. And then you put in hot water because potentially you have to, well, you have to make that a safeguarding disclosure. There is a duty on you to make that disclosure in certain circumstances. But if that's not covered by the COT3, you run the risk of breaching it. So it's just beneficial at that point to take advice about how best to structure that to make sure you're not going to get caught in that situation. We got one here. Are you able to give an example as to how you open a protected conversation where you want to start talking about a settlement agreement? I wouldn't mince around with it. You know, there's no mincing of words. It literally just is this is a pre-termination negotiation. This means that we're going to be making you an offer to terminate your employment. And then normally you'll lead then into some reasons for that. So there's normally a reason for it, whatever that reason might be, of you know, there's potential changes within the business. We might be going through a redundancy process in the future. This may affect your role, and therefore we want to offer this to you because it's going to be more beneficial for you. There might be a capability issue that might affect your role. We might have to go through a performance improvement plan for these reasons. We don't make any particular decisions. We want to make this offer to you because it's going to be more beneficial for your role. And so it's, you know, this is what it is. This is what the potential outcomes are. This is what we want to achieve. This is what the next step's going to be. Nice and clear and clarified. If people don't want to accept it, then no form of making it less confrontational is going to really help. You know, I always think clarity is the best way to go about it. This is what it means. This is what's going to happen. And Lee, the very last one for you. What can you do if you want to have a protected conversation, but the employee refuses to consent? Issues giving rise to the desire for having the conversation are not known to the employee, so cannot have a without prejudice discussion. What do you do if they don't consent?
Well, if they don't consent, you probably don't want to have one, because then they probably go and talk about it. So that's probably that's why it's important to get them to consent in the first place. If not, then if the alternative's a procedure, then you're probably going to have to look at following that procedure. It might be that you can come back to the offer later on if things have changed and it looks more likely that they are going to be fairly dismissed. But yeah, if they're going to refuse, then we're just going to have to, yeah.
A massive red flag, isn't it? Yeah, you can't have a situation where if they don't consent, then don't make them the offer, because anything you say to them will likely be used against you. I know if they don't want to deal with you, don't be tempted to ring them up and give it to them over the phone. Don't be tempted to write them a letter. If they just say no, I'm not coming, that's it. You've got your answer there. And I'd use that open process, as Lee said. So that brings us very nicely to a close. So thank you again all for coming on, and we look forward to seeing you again soon. And thanks very much for listening. Great.
Thanks, everyone.
Have a great time, everybody.